how does the last clear chance doctrine save personal injury claims in Virginia? In Virginia, being even 1% at fault for your own injury can completely strip away your right to recover any damages at all. Virginia is one of only a handful of jurisdictions that still follows the traditional rule of pure contributory negligence, making it one of the harshest fault systems in the entire country. Under this rule, if a jury finds you just 5% responsible while the other driver is 95% at fault, you walk away with absolutely nothing. Insurance companies know this rule inside and out, and they use even minor allegations of plaintiff fault as a powerful weapon to deny otherwise valid injury claims. But there is a narrow and powerful legal lifeline known as the last clear chance doctrine, which can completely change the outcome of an injured person's case. This doctrine allows an injured plaintiff to recover damages when the defendant had a later, independent opportunity to prevent the harm and failed to use reasonable care to do so. The Supreme Court of Virginia has described the doctrine plainly. One of the parties had a last clear chance to avoid the harm and simply did not take it, tracing back to English common law and solidified in the landmark Virginia case, Greear v. Noland Company in 1955. The doctrine divides plaintiffs into two distinct legal categories. The first is the helpless plaintiff, someone physically trapped in a position of peril who cannot escape on their own, where the defendant is liable if they saw or should have seen the danger in time to act. The second is the inattentive plaintiff, someone physically capable of escape but completely unaware of the danger, where the defendant is liable only if they actually saw and appreciated that the person was oblivious and still failed to act. To successfully invoke this doctrine in a Virginia courtroom, an injured person must prove 4 specific elements with precision and clear evidence. First, the plaintiff must show they fit into one of the 2 categories, with courts focusing strictly on the moment immediately before the injury, rather than how the person ended up in that position. Second, the plaintiff must prove that the defendant had actual or constructive knowledge of the danger, depending on which category applies to their situation. Third, the defendant must have had the practical and physical ability to avoid the harm, meaning there was enough stopping distance, reaction time, and space to swerve or brake before impact. Fourth, the plaintiff must establish that the defendant's final failure to act was the direct and proximate cause of the injury, not the plaintiff's own initial negligence. In car accident cases, this doctrine commonly applies when a driver spots a stalled vehicle on the shoulder with plenty of time to respond, but hits it anyway due to distraction. In pedestrian and bicycle cases, a lawyer reviewing the facts may find that a driver had hundreds of feet of clear visibility and still failed to slow down before striking someone crossing the road. When the doctrine applies, it effectively wipes out the plaintiff's prior negligence and allows full recovery. But missing even a single required element will defeat the entire claim. Led by former United States Attorney for the Western District of Virginia, John P. Fishwick Jr., the attorneys at this firm help injured people throughout Roanoke and surrounding Southwest Virginia communities navigate these complex legal rules. If you believe the last clear chance doctrine may apply to your injury claim, contact Fishwick and Associates plc at 540-345, 5890, located at 30 Franklin RD SWC 700, Roanoke, Virginia 24011, United States, to schedule your consultation today.